Well, hello, my name is John Watts. I want to welcome you to our webinar. And what we're going to talk about today is if you've been sued in district court or in small claims court by a debt collector or a debt buyer, what is the overall process or the big picture of that? So let's go ahead and start with this. And I have here a copy of, it's just a typical lawsuit. This is what's known as a complaint. And so a debt collector or a debt buyer, in this particular example, it's Unifund, but it could be Midland Funding, LVNV Funding, Portfolio Recovery, Asset Acceptance. There are all sorts of these debt buyers out there. So they prepare a complaint. And this is a document that gets filed into court, and it says, first of all, who they are. So it's Unifund, Midland, Portfolio, whoever it is. And then it'll have your name on it. And up at the top it says what court it's being filed in. So is it being filed in small claims court, district court? Is it Jefferson County, Madison County, Shelby County? Which county is it? And then it will say what you're being sued for. So it might be $1,000, $5,000, $10,000. And sometimes it'll give you a little bit of information about what this debt supposedly is. So, in other words, you didn't go borrow money from Unifund or Midland Funding Portfolio. You had, typically it's a credit card. And sometimes in the lawsuit it'll say, oh, this is a GE Money Bank, or this is a Chase credit card, or Capital One, City, whoever it might be. And so then it'll say at the end of this lawsuit, it'll say, all right, based on everything we're saying in here, we want a judgment against you for the amount that they're suing you for. All right, so that's what starts the lawsuit. Now, usually the very next thing that happens from your perspective is you get a letter. Usually, well, you may get several letters, but usually there's a letter from a place called Ferry and Nicholas, or Nichols and Ferry, I forget which one it is. But they are a, quote, mediation firm. And they're not lawyers, and they usually will write to you the very next day. So you get sued on a Monday, Tuesday a letter's going out to your house, and so you get this letter and it says, you've been sued, and they may list the name, Midland, Portfolio, whoever, and it'll say, if you want us to help you negotiate or mediate between you and this debt collector, this debt buyer, then give us a call. Now, I'm going to come back to them in just a moment, but you may also immediately get letters from bankruptcy lawyers. Now, in my opinion, you should not get any letters from bankruptcy attorneys until after you've been served. Our ethical rules say you have to wait 7 days, and then 7 days after somebody's been served, then you can send an advertisement letter to them. But some lawyers don't follow that, and so you may get letters from lawyers saying, yeah, you open up the letter, it says, hey, I'm Joe Blow, attorney, you've been sued, I can help you file bankruptcy. Now, my suggestion is, if a lawyer's sending you letters and they're violating the ethical rules doing that, maybe that's not the lawyer that you want to consider, but that's up to you. If you get some letter from a non-lawyer saying, hey, you've been sued and I'll be happy to help you negotiate to mediate this, I think the natural question is, why would I want to deal with a legal situation and have a non-lawyer representing me? That doesn't quite sound right. But again, use your own judgment on that. I'm just wanting to walk you through the process. So the first thing is you get sued. Usually then you get notified by either lawyers or this Ferry and Nichols place. And then the third step is you'll actually get served. And that's where it could be a sheriff's deputy. It could be a private process server. There's one called Van Slam that's pretty prominent. And so they knock on your door, or they walk up to you in your driveway and they say, hey, here's some legal papers for you. And now you've been served. And so being served is significant because that triggers the clock. to start running on how long do you have to respond to this lawsuit. And this video is really about being in small claims or district court, and you have 14 days to respond. And I should have said this, we're only talking about lawsuits in Alabama, and so that's what the time period is. 14 days from when you've been served. Sheriff's deputy, van slam, some private process server, or even certified mail. You can be served by certified mail. You have 14 days. Now, what if you don't do anything? And unfortunately, this is what about 80, sometimes 90% of people, this is their response, is nothing. They do nothing. If you do nothing, when that 14 days runs out, then this company that sued you, Unifund, Portfolio, Midland, Asset Acceptance, LVNV, they are going to file a motion or an entry or a notice, all different ways to describe it. Here's the bottom line. They'll get a default judgment against you. Now, if they get a default judgment, that is a real judgment, and now that opens you up to garnishment of your wages, 25%, garnishment of your bank account, selling, so the seizing and selling of your car, of your house, put a lien on your property, all sorts of things that can happen. So definitely want to avoid that default judgment. So, all right, you've been sued, you've been served, you're looking at your time, you go, okay, I want to take some action. What do I do? Well, and we have a long video on this, so I'm not going to go into much detail, but you have 5 options. You can file bankruptcy, very rarely appropriate, but it can be appropriate. You can fight this lawsuit on your own, so you don't hire a lawyer. You can settle the lawsuit on your own, so you don't hire a lawyer. You can hire a lawyer to fight the lawsuit or hire a lawyer to settle the lawsuit. Now, normally if you're hiring my firm, these last 2 are combined because we respond to the lawsuit and we go to the debt buyer, the debt collector, and say, look, you've got a choice. You can drop the lawsuit, we'll pay you no money, you get off of our credit report and we won't sue you, or we'll go to trial. And so that's the option. We don't really negotiate other than we say, do you want to fight this or do you want to settle this and get this off our credit report and go away? Those are really the options that we give to the debt buyers. But again, I go into that in a whole lot more detail in a video that you can watch. But let's say that you go, you know what, I want to handle this on my own. What do I do? Well, the most critical step is to file an answer to this lawsuit. Respond to it. Now, if you've been sued in small claims court, they'll give you a little form answer. It's going to have 4 boxes, A, B, C, D. And I think box A says you sued me in the wrong county. Box B says I admit everything. I think box C is I admit I owe the debt, but I don't admit I owe the full amount that you claim. And box D, and frankly that's the only one we deal with, is I deny owing anything. And then it gives you a little space you can type something in or handwrite something in. Now in district court, you normally are not given that form, but you can find it online. Or you can handwrite an answer, type an answer. There's really no magic form. Here's the bottom line. You want your name and the name of the company suing you. You want the case number, and that's going to be in the upper right-hand corner, and it'll say something like SM for small claims, or DV, that's district civil. And you want to write that number in, and then you want to put what you're saying in your answer and then sign it. And then you file that into court. So what do you put in your answer? Well, I don't represent you, so I can't tell you what to put in your answer. This is not legal advice. What I'm doing is giving you general educational advice just so you can see the big picture of what's going on in these lawsuits. But I'll tell you what a lot of people put down is they say, wait a minute, I've been sued by Unifund, by Midland, LVNV, Portfolio, Asset Acceptance. I never did business with those companies. I never borrowed money from them. They never fixed my air conditioner, fixed my car, fixed my roof. I've never had dealings with them. So if you never had dealings with these people and you get sued by somebody that you've never done business with, I think the natural thing is to say, wait a minute, I don't owe this company any money. That's box D. Now, if these guys can come into court and prove that they own the debt, I don't care if you owe GE Money Bank, Capital One, Chase, Citi, whoever it may be, those guys didn't sue you. But if a debt buyer sues you, then they have to prove you owe the debt. And if they don't, they lose. But even if they prove this, they have to prove that you or that they own the debt. Now, I don't know of any way that you could know whether or not they own the debt when you get this lawsuit, because it just says they own it. Well, they could say you owe $1 billion. Just because they say it doesn't make it true. So most people file an answer, they check that box D and say, hey, look, I don't owe the plaintiff any money. Plaintiff is the company suing you, the debt collector suing you. Well, what else do you put in there? Well, you can put other what are called defenses or affirmative defenses. That's where you say, even if I do owe the money, and even if Unifund, Portfolio, whoever owns the debt, they still lose. I'll give you the most common one, statute of limitations. We say statute of limitations, Alabama, 3 years. The debt collectors say it's 6 years. So which one is it? Well, ultimately it's for your judge to decide. But I think that there's a very strong argument, and the correct answer, the correct analysis is 3 years. Almost always these guys are suing you beyond 3 years. So a lot of people put that in their answer. They put, I don't owe the plaintiff any money, and statute of limitations has expired. And so what do you do with that answer? You take it to the clerk's office. So you go to the courthouse, usually there's security, and you say, hey, look, I was sued in small claims or district court. I've got my answer. Where do I go? And the security guys will be able to tell you. They say, oh, well, that's on the first floor. That's on the 5th floor. You know, here's where you go. And you walk in there and you say, same thing. I've been sued, and assuming this is true, I've never done this before. I want to file my answer. Am I in the right place? And usually people in those offices are very nice to work with. And so take you a couple of copies of it so you can give one to the clerk, and then he or she they will stamp that in with a date and time so that they know when it was submitted. They put that in the file. And then you want to give them a copy to stamp in, and you keep that so that you've got proof, yes, I did file my answer. And then you want another one to be able to send to the collection lawyer. And my suggestion is, when you get home or get back in your car, take your phone, take a picture of your answer. Make sure you can see where the stamp is showing the date and time. And that way, if somebody ever comes back later and says, you never filed an answer, and we've had this before, where the collection lawyers will say, I want a default judgment because that 14 days has expired. Remember, you get served here, you go 14 days, now your time's gone. They can move for a default judgment. And they say, you never filed an answer. You want to be able to say, wait a minute, I've got this right here. I've got the answer. See, it's stamped up here. So why do I say take a picture with your phone? Well, what if you lose this? You've got it on your phone. But don't just leave it on your phone. Email the picture to yourself. If you have a Gmail account, Yahoo account, some account that's going to be up in the cloud, email it to yourself so that, again, if you drop your phone, you lose your phone, this paper gets destroyed, you've got the proof of it. All right, so you file your answer. What happens next? Well, usually the very next thing is you get a trial date, and that will come in the mail. Usually it's not a full-size letter. Okay? Usually it's going to be about, I don't know, this size. And for most of us, it's about the same way we get our voter, I forget the technical name, but you know the little card you get says, here's where you go vote, and you kind of tear it across top and you open it up. That's usually what the trial date comes in. Now, some courts will send it in a letter, and you open it up, and it says, be at trial at 9 a.m. at such and such courtroom, but it may be very, very small also. So here's the bottom line. You file your answer. You tell everybody that lives with you, nobody throws the mail away without me looking at it. And somebody, well, these are just a bunch of advertisements. No, I don't know what they are. See, and I say this because it's true. Between the Papa John's coupon and the Captain D's coupons, this little thing may get accidentally slipped in there. So if you go, it's just a bunch of ads, you throw it away, you may have thrown away your trial notice. It's not going to come certified mail. The court has no obligation to call you. They don't have any obligation to make sure you receive it. So you need to be checking your mail every day. Go through every piece of paper, say, did I get anything from the court? I'll just tell you this, in most counties, you're going to be trying your case 4, 6, 8 weeks after you submit your answer. So if you don't get the little trial notice within about a week, I start calling the clerk's office. Say, hey, this is John Watts. I got sued by Portfolio. Here's my case number. I filed my answer about a week ago, or 2 weeks, or 3 weeks, or whatever, and I haven't gotten a trial date yet. I just want to make sure I hadn't missed that. And as long as you're nice to them, even if you're not nice, they're usually nice, but particularly if you treat them with respect, they're going to be very nice to you. And they're going to look up your case and say, oh, we haven't set it for trial, or yes, we have set it for trial. Here's the trial date. Now, a little bit of advice. This is true of when you go in to file your answer and when you call the clerk's office. Be respectful of them. Don't walk in Monday morning at 8:30 and be impatient for them to do. Don't go Friday afternoon at 5 o'clock. Try to go when it's not going to be so crazy, or if it is really crowded, just be very patient. If you're calling them on the phone, again, I wouldn't call right when it's the busy time for them. And just check in every 3, 4, 5 days with them till you get that trial notice. All right, you get the trial notice. On July 15 you're going to trial. What do? My suggestion is, if you're handling it on your own, let us know. We can send you some information about mistakes that people often make. And I think we have 7 of them. And I won't go into that here because you can look at that information we'll send you. But that may help you. Here's the other thing you do. Go to court before your trial date. So your trial date's here. Back up a week, 2 weeks, go to court. I don't mean just any court. I mean your judge. So if you have Judge Amari in Jefferson County, if you have Judge Allsbrooks in Shelby County, if you have Judge Smith, wherever, go to their courtroom and watch when they are doing small claims or district court trials. Not criminal trials, but civil trials. So here's the way you do it. Pick up the phone, call the judge's office. If you don't know who your judge is, you can call the clerk's office and say, hey, who's my judge? They tell you who the judge is. Call the judge's office and say, look, this is John Watts. I got sued by Midland Funding. I have a trial date, July 15. I was wondering, are you going to have any other trials before then so I could just come watch and see what happens? I've never had anybody do that where they got any response other than this. So everybody that's done this has gotten this response. The court is very friendly, very nice, actually pleased that you're calling, because these things are open to the public, but really the public never comes in to watch what's happening. And so the judges like for the public to see. And if you're going to represent yourself, they really like for you to come ahead of time so that you know the process, you know what's going on. So why do you do this? Well, I want you to know where the courthouse is. I want you to know where the judge's office is. What's parking like? How do you get through security? Where do you find your judge? And here's what happens. A lot of people, they'll say, oh, I want to handle this on my own. I don't want to pay any money to a lawyer. That's fine. And I tell them, here's what you need to do. Go watch trials before your trial. And they go, I'm too busy for that. I don't have time. I don't need to do that. I know where the courthouse is. Okay. And then they call me after their trial and they've lost. Well, what happened? Well, I I got confused where the courthouse is, and so I was running late. I couldn't find a parking spot. I had no idea on Monday morning there'd be a lot of people there. And then I go through, and I forgot about security. I had to stand in line, and I'm like, oh my goodness, I'm going to be late. I didn't know you had to go through security. And I finally get through security, and I can't remember which courtroom it's in. So I sat in the wrong courtroom, figured it out, got to the right courtroom. They were already finished, and the judge didn't seem happy that I showed up like 25 minutes late, and I panicked, and I just agreed to a consent judgment. Well, that happens repeatedly, over and over. Here's the solution. If you're going to do this on your own, and you're not spending money, then spend time. Go the week before. So here's your trial. Go the week, 2 weeks before. Find where you're supposed to go. Find out about parking. Find out how security works. Then what do you do when you get there? You sit down. You look around. Have you a notebook? Take a notebook with you. Make notes. What happens when the judge walks in? Normally, everybody stands up. What happens when the judge does what's called the docket call? That's where the judge will be sitting there, and the judge will say, all right, I'm calling these cases Midland versus Smith, LVNV versus Jones, Portfolio versus John Watts. And you'll see people stand up. Lawyers stand up. People who are there representing themselves will stand up. Except here's what you'll see. If there are 10 people representing themselves, about half of them will stand up. Well, what do the other half do? They don't show up. They lose. So, gives you an idea. You've got to show up. And then you just watch and observe what happens. It'll make you so much more comfortable. Let me tell you this. I've been trying cases for 20 years. When I say trying cases, I mean federal court, jury trials, state court jury trials. Things that may last a day, 2 days, a week. So I tell you that not to brag, but just to say, I've been doing this a long time, and I've got a ton of trial experience. If I'm going into a new courthouse, I want to get there beforehand. Even if I'm familiar with the courtroom, I want to go to that courtroom. Sort of get a feel for where do I sit? Where's the jury? Now, you don't have to worry about a jury trial, but where's the jury sitting? Just so you can kind of soak it all in. Because what I want to do is remove a lot of the nervousness. Now, I don't want you to walk in and have no concern. Because if you walk into a trial, your trial, the morning of your trial, and you have no concern about it, you may be dead, okay? You need to check your heart, because your heart ought to be pounding on this, but it ought to be under control. That just means you're interested, that you care about this, you want to do well. If you walk in and you're like, I don't care, that's not a good situation. Because if you don't care, you're not even going to show up. So you want to care, but you don't want to be just overwhelmed with nervousness or anxiety. So what happens at the trial? Well, so a lot of times the collection lawyer will have some papers. You'll see him and he'll say, come out in the hallway with me. And the judge may say, go out in the hallway with this lawyer. I say, look, I got all these papers. I got statements. So that proves you owe this debt. No, that proves that you have statements. That's all it proves. He goes, well, I mean, we got statements, so you owe the money. I don't know if I owe the money or not. I don't know who you are. Oh, well, we're in Midland, and since we have the statements, that proves that you owe us the debt. No, that proves that Midland sued me, and Midland has copies of statements. Obviously, I'm being silly when I say this, but that lawyer's got the paper. If somebody walks by and grabs those statements out of his hand, now that person has the statements. What does that prove? All it proves is that person has the statements. It doesn't prove you owe that person any money. So this whole thing about, oh, I got the statements. A lot of times the lawyers think like, this is the gospel truth here. No, it just means you've got the statements. There may be a dozen companies that have copies of the statement. Doesn't mean a dozen companies can sue me or that I owe a dozen companies. If I owe the debt to GE Money Bank, and GE Money Bank has sold that debt, I only owe it to whoever truly owns that debt. Well, Midland says, but we own it. I don't know. Do you? We're in court. Prove you own it. They don't like that. And they'll say, tell you what, I've got, here's what I have. They'll take the purchase agreement, and a purchase agreement is just a contract. I mean, it's kind of funny. Sometimes they act like, well, there is nothing in writing. No, you don't buy $500 million worth of debt on like a handshake or what, a text message? No, there's a contract. They'll bring you the first page of the contract. And they'll say, see, here it is. And written across it will say purchase agreement. It'll say Midland and GE Money Bank agree to a sale of the accounts listed in Exhibit A, and there are no representations made other than what's in the purchase agreement. They go, see, here it is. We proved it. It's one piece of paper. This is the contract that you bought $500 million worth of debt? Oh, well, no. See, this is the front page. This is all we're going to give you. Well, if you bought the debt, why wouldn't you introduce into evidence the whole agreement? Oh, that is super secret. They don't even give that to us. Well, that's a little bit of a problem because Midland sued me in court. So Midland has to prove it owns the debt. They go, yeah, but I mean, we wouldn't make this up. As if all this stuff with the big banks, Bank of America, Chase, making documents up. Remember robo-signing? Where they had people signing thousands and thousands of affidavits a day to take people's homes. And the people signing the affidavit said, I swear, this information is accurate. You know what the problem was? They had people doing that were dead. Well, how does a dead guy sign an affidavit? They just had them like a stamp, just signing over and over and over. Or they had the notary who said, yeah, this person really signed. They were dead. They just had them already notarized. Nobody was looking at this stuff. So really, some debt buyer that comes along and buys something for pennies on the dollar, they want to come into court and go, well, I mean, if we sued you, you have to believe us. No, actually, I don't. Okay? I don't believe you. So you have to prove it. And bringing in one little piece of paper ain't going to prove it. So they go, oh, well, in addition to this, we have another piece of paper that has your account number on it. So what? What does that prove? Besides all that, a piece of paper isn't going to do it, in my opinion. They have to bring a witness to say, all right, here's the debt. So this will represent your debt. GE Money Bank has it. Well, you're being sued by Midland. How did it get from here to here? Well, I understand there's a piece of paper, but somebody's got to come in and testify for GE Money Bank and say, yes, we sold it to Midland. Well, what if they sold it to another company who then sold it to Midland? Well, now you got to have more witnesses there. And let's assume, I've never seen this happen, but let's assume they can prove it goes from GE Money Bank to Midland. Does Midland still own it? Or did they transfer it to this guy over here? I don't know. Somebody's got to come in and testify. Now, here's what these debt buyers say. I say, that is outrageous. We are not going to send a witness and we're not going to prove all this stuff. I mean, we sued you. And remember, we got the statements. That's all the proof. No, can't even get statements into evidence. But they go, well, this is unfair. This is going to really be a burden on us. I tell you what, when I sue these debt collectors in federal court, Midland Funding, LVNV, Portfolio, Asset Acceptance, Unifund, all these different debt buyers we sue in court, I don't go to trial and say, yeah, I don't have any witnesses. I don't really have any paperwork because, you know, it's kind of outrageous to expect me to prove my case in court. I mean, come on. I said that you did this bad stuff. That ought to be good enough. I would get thrown in jail by the federal judge if I did that. But they come into small claims in district court and they're like, yeah, I don't have anything. I shouldn't have to prove anything. No? if when I get sued and I get served, or I can even file an answer before I get served, but if I file an answer denying that Midland or Portfolio that you own this debt and that I owe you any money, well, then you do have to prove it. That's why we have trials. And, it's easy to talk a big game, but at trial, they have to walk the walk. They have to prove it. Now, what happens at trial if let's say they win? So, they prove you owe the debt, they prove they own it. They win, now you have a judgment against you. You can either pay that judgment, you can do nothing, they'll garnish your wages, garnish your bank account, same thing as a default judgment, or you can appeal it. You have 14 days to appeal it to circuit court. Well, what happens in circuit court? It starts all over, as if what happened down here in small claims or district court never happened. It's because you have a right to a trial by jury. What if you win? Well, Midland, Portfolio, whoever, they have 14 days to appeal it because they have a right to a trial by jury. And we have no juries in small claims or district court. So what if you win and they don't appeal it? What does that mean? Well, what it normally means is you do not owe this debt. So Midland sued you, said you owed $5,000. Now you have a judge that enters an order that says judgment for defendant. That means you do not owe Midland that money. So what are the implications of that? Well, did Midland credit report that you owed them $5,000? Because now we have an order. Midland started this fight. They started this lawsuit and they lost it. But they've been telling the world that you owe $5,000. And now we know from this order you don't owe $5,000. Seems like a problem for Midland. And they sued you and said you owed $5,000. It's a problem. And before they sued you, they wrote you a letter probably, or had their lawyers, Zarzar or Holloway and Moxley, write you a letter saying you owe $5,000. Well, it turns out that's not true. And then what did they do afterward? We've even had, it's amazing, Main Street Acquisitions. It's a debt buyer. They sued our client and lost. And then they wait, I don't know, a year and a half later, they sue him again. The same debt. So Main Street, same defendant, same debt, same court. The only thing they did is they switched collection lawyers, because you can't go back to the same collection lawyers. Would you sue again? Because that's like the most egregious, the just most horrendous example of a bogus debt collection lawsuit. Because once you lose, it's over. And they did it again. So we see that. Sometimes we see people continuing to credit report. We see debt collectors, debt buyers writing you letters saying, you still owe the money. I've had him even say, I've had the same collection law firm say, pay us the money. If you don't pay us, we're going to sue you. It's like, did you remember we already went down this trail? So when that happens, they owe you a bunch of money. Because you're going to sue them if you choose to do that. And if you're successful, it's pretty terrible conduct to do that. What if they continue to keep it on your credit report? That's wrong conduct. And just going back to, they had on your credit report, said you owe $5,000. They claimed you owe $5,000. They wrote you a letter saying you owe $5,000. They sued you for $5,000. And it turns out you owe them $0. That's a problem under the law. So I hope that this big picture overview is helpful to you. I haven't tried to get into all the details, all the exceptions to the exceptions, but just to give you kind of a big picture of, okay, I've been sued, what do I do? And if I want to try this on my own, how do I handle that? So hope this is helpful. My name is John Watts. You can contact me at 205-879-2447. Or you can go to our main website, alabamaconsumer.com. There's a Contact Us button. There's a whole section. We just have a ton of videos and articles about being sued by debt collectors, by debt buyers. And if we can help you in any way and you live in Alabama, just reach out and touch us. Give us a call, contact us through the website. If you like this video, there should be an option to like it or share it, or you can comment below, and we appreciate you helping us to get the word out there so that people will not have a default judgment, but instead will take action. And I want to congratulate you, because I know that you're going to take action after watching this. So let me know if I can help you in any way. Thanks. Have a good day.